I think we have learnt a lesson in this regard. And in the past, emotions have been much more high, and our democracy has been much more volatile. And we did cave into the temptation during a democratic rule in 2015 through the 21st Amendment. And at that time, the reason given were that those who we are aiming to bring in the fold of or jurisdiction of the military courts are hardened terrorists, and because of the current situation of the country as it was then, there was legitimate fears and apprehension amongst the judiciary and amongst members of the bar vis-a-vis their own safety, and it was thought or deemed that regardless of whatever may be done in the short term, efficient and effective trials would not be able to be conducted. And begrudgingly, I believe the Supreme Court allowed this, and it was to be a purpose for a period of 2 years, and then its tenure was extended. But the trials which were held of those hardened terrorists, as we are told, in the military courts, the details of which were revealed in the judgment of the Peshawar High Court by the late Chief Justice Waqar Seth, as he examined that almost every single conviction had been secured primarily, or rather in some cases solely, on a confessional statement of the accused. And in almost every case, the statement and the format and the drafting of the confessional statement was identical. And many legitimate questions were raised. Because what we need to realize that after the 18th Amendment and Article 10A, which guarantees a right to a fair trial, we have to now proactively aim to secure the rights of any accused in court, and we have to jealously guard his or her democratic and constitutional freedoms. And there has been in the past, before this article was introduced in the Constitution, a Supreme Court held a view in 1975 in the case of Brigadier FBLE, which is cited as the precedent which allows for civilians to be tried in military courts. At that time, it was under the amendment introduced by dictator Imran Khan in the year 1967 through an ordinance, whereby it brought in within the jurisdiction of military courts those civilians who had committed any offense under the Official Secrets Act 1923, or who were accused of seducing or attempting to seduce military officers to be disobedient and disregard their orders. Now, the Official Secrets Act, the name is very misleading. One would feel that this is an act which, tries one for the offense of espionage, or so if somebody is caught spying on national security secrets. But the ambit of the Official Secrets Act is very wide. It makes it an offense for anybody to take any picture within a notified area, and that could be, for that matter, every single square foot of the GHQ, even though the intention of taking that image is never to share or even share for the purpose of espionage, and it may be recorded for any other reason, but it is an offense. And if anybody retains such image to throw is being transmitted to you by somebody else, that is also an offense. If somebody impedes in the deliverance of service of any military officer, so for example, if you are arguing at the gates of the Corps Commander House or of the GHQ with the security guards over there and resisting their orders and not moving back and attempting to open the gate, you would very well be deemed to have committed an offense under this act. Then there is also the offense of incitement, that if you are present there, or your presence could be deemed as evidence of incitement, your mere presence, as these laws are very interpreted not in the fairest manners. So if you've been inciting anybody to take a picture or retain a picture or interfere or impede in the performance of service by a military officer or a law enforcement agency officer over there, you'll be deemed to have committed an offense. So these offences were added in the 1967 ordinance by Ayub Khan, and a case under this law of a retired military officer who was deemed a civilian, Brigadier FBLE, went all the way to the Supreme Court, and the Supreme Court said that what is a law but instructions given by an authority and which can be enforced by a court. And it said that the law doesn't have to be good or moral in order to be considered a law. Now, that was a interpretation of the Supreme Court, or the view of the Supreme Court in 1975. After Article 10A, I believe the Supreme Court, if it is to review the vires of these provisions of the 1967 ordinance, I believe they would have a much different view, and the Bar Councils of Pakistan should consider, in all seriousness, filing multiple petitions before the Honorable Supreme Court or the respective High Courts to challenge the vires of these provisions now under the 1973 Constitution as it stands today. I believe one could have reference to the judgment in the case of Ghulam Hussain by the larger bench of the Honorable Supreme Court. It was authored by the then Chief Justice Asif Said Khosa, and it takes a very conservative view when interpreting terrorism, and it of course denotes that if it's a group which is known to be indulging in violence for purposes of promoting or propagating their religious views or their political views, and they intend to overawe the government, and if that is something done in a systematic manner to achieve certain aims, then yes, it would fall under that. But I do not think that ad hoc protests, because unless it was announced a week in advance that this is the manner in which Imran Khan is going to be arrested and this is the time Imran Khan is going to be arrested, I don't believe that the people who came out, all of them, were part of some larger conspiracy. And I think a majority of the participants were perhaps those who, after hearing the news, as a spontaneous reaction, spilled out on the streets. And because otherwise there are clear parallels or distinctions you can draw in the political narratives or in the political messaging given by political parties. And yes, Mr. Khan is not known as a pacifist. Mr. Khan is known to create hurdles in the smooth proceedings of the law. He is known to have resorted to violence whenever he's been called to courts. And but at the same time, the question more so, I believe, which is concerning the authorities in Pakistan, is not that the protests were violent, because many political parties in the past have done violent protests. It's who the protests were directed towards. Now, I beg to differ that it was only Mr. Khan who is to blame, that now a significant section of the public or the polity believes that major decisions within our corridors of power are taken solely by the military. Mr. Nawaz Sharif has been at pains to tell the nation that it was not the Supreme Court, it was the military chief who got him out of the office, because it is he who used to ask, "Mujhe kyun nikala?" When political cases or cases which are deemed to be of political nature, even though they primarily relate to corruption charges, were reopened or were being aggressively pursued against Pakistan People's Party, and a lot of media coverage was being given to those cases. In 2015, Mr. Zardari addressed the military elite and said, "Main eent se eent paja dunga." When PDM was launched and Maulana Fazlur Rahman gave call of the first long march, he, in order to, I believe, rile up his supporters, uttered publicly the words that this long march will go to GHQ if need be. So I believe that for the past many decades, every single political party, when it is on the receiving end, is at pains to tell the people that who is responsible for the decisions which are being made. So I think a significant portion of the population now believes that. Does that mean that protests should have been violent? Does that mean that things should have been done in the way they were? Does that mean that Mr. Khan should have been so late to condemn the action? Does that mean that anyone who was actively involved in specifically instigating acts of violence should be absolved? No. But the reaction which is being given by the state authorities, and being done so through the veil of democracy under the PDM government, is condemnable, deplorable, and a constitution is dying a disgraceful death at the hands of the elected. Well, it fundamentally denies a citizen the right of a judicial trial. A judicial trial is in civilian court, is the procedure of which is determined by our criminal procedure code or our civil procedure code, and those procedures have been vetted by the judiciary time and again, and then principles have been introduced because of the constitution and the constitutional freedoms, and certain maxims of justice which we rely on, and all of those is denied to you. They are in-camera trials. B, your access to your lawyer and the privilege a client and a lawyer has are denied to you, and the access of lawyer is not as freely as one can choose to do so. B, the way the evidence is examined and the onus on the prosecution, that varies a lot. The credibility associated to the evidence and the barometers for that varies differently. The consideration of the judge who is sitting over there are completely different when dispensing justice, as opposed to a civil judge who's been trained in the proceedings of judicial trial. So there are fundamental differences, and the procedures are there to regulate and ensure that nobody who's come to court or surrendered before court, because when an accused is before court, he is deemed to have surrendered because he's not attempting an escape, or even if he has come to court through application of a bail, he's deemed to have surrendered and he's thrown himself at the mercy of the court. So the court is to ensure, the burden is on the court to ensure that a fair trial has been carried out, and the burden is of proving guilt is put entirely on the prosecution, and there's no presumption of guilt. These rules or these ethics are not followed when there's a martial trial. The law says that you would have a right to a counsel, but then it also immediately says that if there is an issue, that a lawyer may be provided to you, and I believe that's what's done, because the point is, if you, the media, or the families don't have access to those who are being presented before the military court, as they say, the legal process has already started, so said by the army chief, who is to ensure that were they actually asked about which lawyer to engage, and were they given the chance and the time and opportunity to engage that lawyer, and did a meeting with that lawyer indeed happen, or have they only complied with the paperwork? I mean, if somebody is filling in a form for me and forcing me to affix my stamp or my signature or my thumbprint on it, what is to ensure? Because there is no transparency, because these records are not public records. I mean, till date, have we been able to determine and find out how was Idris Satak's trial carried out? How was Hassan Askari's trial carried out? We know how they were abducted, we know how they were taken away, but beyond that, how exactly were the trials carried out? Even though with all the challenges, because people weren't present, people did not know, they were not in court to know what happened and how the matters were conducted. Well, the Honorable High Courts, the Supreme Courts have power within the Honorable High Court under 199 have judicial review powers. The Supreme Court has under Article 184.3, and they can view the wise of a law, or whether be it in the form of an act or a ordinance, and they can see that whether it and test it against the threshold of the constitutional freedoms given in Chapter 2, including the right of due process and the right of fair trial. And then decide that does this fulfill those parameters or not, and does it stand to be a good law or not in that light. And if they strike down that 1967 ordinance and the amendment made in the Military Act as being ultra vires, then all these trials will be suspended and none of these citizens could be tried in the military court, and automatically their trials will be referred to either the anti-terrorism courts or the ordinary sessions court, given the nature of the offences they've committed.